Thank you, Madam Clerk. Call the next case, please.
Braylen, Bennett versus State of Tennessee.
Good morning.
Good morning, Your Honor. May it please the court, Ann Short appearing for Braylen Bennett in this appeal. Braylen Bennett is serving a 40-year sentence pursuant to a plea to 25 felony offenses that he entered on September the 14th of 2015, the very day he was scheduled to go to trial. Braylen was 22 years old. He had no criminal record.
Could you pull your microphone down a little?
Yes, Your Honor.
Thank you.
Is that a little better?
Yes.
Thank you. The threshold issue in this case is, was the plea constitutionally voluntary? To be voluntary, you have to have a record that demonstrates that the nature and elements of the offense were explained to the defendant and that he understands and that he is admitting that his conduct satisfies each element of the crime. Now, the U.S. Supreme Court has told us that a Rule 11 record presents a very daunting barrier to finding a plea involuntary, but it is not invariably insurmountable. The best example we have of such a case in Tennessee is the Tennessee Supreme Court's decision in State versus Crow, holding that a defendant's plea to facilitation of first-degree murder was involuntary. The evidence in this record, we say you will find, is clear and convincing that the circumstances surrounding Mr. Bennett's plea are nearly identical to those that were found in Crow. There were many, but there were four key things that the Tennessee Supreme Court focused on in Crow. The trial court did not discuss with the defendant the nature and elements of the offense. The defendant always maintained that he had nothing to do with the beating and the stabbing of the victim. He was never informed that he was admitting he furnished substantial assistance, i.e. facilitation, in connection with the murder in the case. And although the plea agreement stated that the plea was voluntary, there was no explanation whatsoever in the plea agreement regarding the elements or the nature of the offense in that case. Now, Mr. Bennett's case. Mr. Bennett pleaded to guilty to facilitation of first-degree murder and 21 other felony offenses by way of criminal responsibility. So when we look at the indictment, it did not charge facilitation. So reading through the indictment, Mr. Bennett did, he's not going to see that. Indictments are not required either to allege criminal responsibility for the conduct of others in the case. That doesn't help us. The trial court in the plea colloquy did not discuss the nature and elements of the 25 offenses. But plea colloquy is a little confusing in other respects. The trial judge told Mr. Bennett and others that he was pleading guilty to 11 criminal offenses. And what's happened in this case, and we mentioned in our reply brief, counts were merged and duplicated, and there really needs to be new judgments prepared for some of these things. But the court told him you're pleading guilty to 11 offenses. Trial counsel during the plea colloquy never represented on the record that he had covered and had advised Mr. Bennett about the nature and element of each of these offenses. The plea paperwork, the underlying agreement, incorrectly identified 8 of the indictment offenses. And you have to look in the back of it to say, okay, well, what was he pleading guilty to? The indictment offense, for example, counts 1, 2, and 3 were identified as Class C felonies. Well, if that had been gone through with him and he got to the back and said, what are you pleading guilty to, 1, 2, and 3, it's a Count B felony. Kind of like, wait a minute, how did I go from a Count C felony to a Class B felony in the case? The prosecutions, when they gave the statement recitation of the facts as part of the plea in the case, did not address the nature and elements of the offense in terms of Mr. Bennett's personal conduct. This was a group plea, okay? So what the submission transcript's going to show, for example, are a lot of the state would show they did this. The state would show they did that. The state would show they were involved in this. Mr. Bennett's name is never even mentioned until the very end, and it's in connection with him being the driver of the Jeep Cherokee that is stopped in the case. The record, he was never informed, he was admitting that he furnished substantial assistance in connection with the murder.
But ultimately, he was there at the guilty plea and he agreed with the facts, right?
He was asked, do you agree with that? Yes, he did, Your Honor.
Okay. And at that point, presumably, he could have clarified or added, on the second one or on this circumstance, I wasn't at that one, or he didn't offer anything like that to the
I'm
judge.
sorry, Your Honor, didn't quite catch you.
He did not offer any additional facts or clarification as to the state's facts when he accepted the plea, correct?
That is correct, and that was the same circumstance, Your Honor, that Mr. Crow was in when he pleaded to the facilitation of first-degree murder. He did not. He agreed with the factual recitation, did not add anything. It was not until after his plea, he hired a new attorney. His relatives said, wait a minute, something's wrong here. He hired a new attorney and said, I don't understand this. I did not personally commit any of the offenses. Somebody's going to have to explain to me what's going on with it.
Okay.
And also,
I understand your argument. One more before I lose my train of thought.
yes, sir, I'm sorry.
I understand your argument on the facilitation, and you were talking about that, but you made a comment about the criminal responsibility not being alleged in the indictment. Criminal responsibility is a theory, isn't it? Like the principal theory, it's called in certain other states. Does it have to be alleged in the indictment?
No, it doesn't. In Tennessee, there's clear case law that says it does not have to be alleged in the indictment. So the indictment, we suggest, if you just look at it and say, well, as long as Mr. Bennett could read, then he would have some understanding of what conduct by way of criminal responsibility he was going to be admitting, that he solicited, that he directed, aided, attempted to aid in the kidnapping of people in the house, of the shooting of the dog, shooting of Sidney Smith, everything that took place in the house. And he was never informed of any of those matters, Your Honor. Lead trial counsel testified that what he recalled was explaining to Mr. Bennett how many counts there were, the percentages, I'm assuming that means red dates, if at all, and a synopsis of some of the highs and lows of the state's proof. Trial co-counsel had no specific recollection whatsoever of reviewing the 25-count indictment with Mr. Bennett. Now, there may have been a lot of, here's the discovery, here's our summaries of discovery, but not reviewing the indictment charges. Trial co-counsel also testified unequivocally, Mr. Bennett always maintained he had nothing to do with that house and what went on inside, that he ran away. And during one of his jail telephone calls, which of course all defense attorneys hate to hear those from their clients, he admitted that. He said, I was there, but I ran away like a little bitch. in the case. He always maintained that. During the post-conviction testimony, he was trying to explain, he said, I'm here because of what my charge partners did. I'm not here for what I did. And even the post-conviction court in this case, when you read its opinion in that, it concluded Mr. Bennett still doesn't understand the concepts of felony murder and criminal responsibility. Now, the prosecutor in the post-conviction, she took a shot at it, seeing if maybe he would understand or did understand back then the kind of analogy she drew upon basketball. Braylen was a basketball player. And she said, now, you're aware that the team gets credit for each basket an individual makes because you're part of the team. I don't think that goes far enough to helping him understand what conduct he is admitting he engaged in to solicit direct aid or otherwise facilitate in this case. When I asked trial counsel, how could he be confident Mr. Bennett made a knowing, intelligent, voluntary decision? The answer, to be charitable, was incomprehensible. 3 parts. 1, that's the way our office does it. Number 2, I told Braylen to wait until Monday to give me an answer. And number 3, that his agreement required him to be debriefed afterwards. That was his opinion in the matter, Your Honors.
No, let's back up a second. You're talking about when he talked to him on Sunday or whatever it was over the weekend before the trial?
Your Honor, we dispute that.
Well, I know you just, I was saying that was his testimony, right? That was Mr. Isaac's testimony, was he met with him like the Sunday before and went over the plea with him?
He said he met with him.
That was his, going with what his testimony was. I don't want to, not what your interpretation is, but what he testified to. That's what he said. He said he met with him. He said, went through what the plea negotiation was, what the state was offering, what he was going to have to do, including, I think one of the things was he was going to have to be willing to testify against a co-defendant. Was that one of the things they had to do?
He had to agree to be debriefed, and I think implicit in that was if they wanted him to testify.
But your client was concerned about that because he apparently later called him and said, hey, they've had this trial and I didn't testify. Is that going to affect my plea?
Correct, Your Honor, but that does not in any way address the voluntariness issue.
What I'm going to get to, though, is he sets out, here's what the plea requires. And then he says, I'm going to give you some time to think about it. Let you think about it overnight. We'll talk about it in the morning. Because apparently Mr. Isaac was testifying that he was afraid the other co-defendants were going to cut a deal and then his client was going to be left on the outside. I think that was part of the concern that I think one of the other attorneys had, that there was going to be this deal made and they were going to be cut out of it. So he let him think about it. Now, I've heard a bunch of these cases where they come down and say, my lawyer made me plead. My lawyer, forced me to plead and didn't give me any options, and I just went ahead and did what he told me to do. In this case, it's pretty clear the testimony was he let him think about it overnight. He didn't push him into it. He said, I want you to think about this and we'll talk about it tomorrow. So he had a chance to think about it. The judge then has this conversation with your client about voluntariness, about his understanding of what was going on. And every answer your client gave indicated that he didn't have any questions, that he was happy with what his lawyers did, and that this was his decision. That's
Are we
my
talking?
record.
I'm sorry,
When he
Your Honor.
pled guilty.
When he pled guilty,
Yeah.
yes.
You understand?
Yes.
So now we have a situation, and again, I look at it from the standpoint he was under oath, obviously, when he testified then, or when he told the judge then, he understood all these things. And then my understanding, what you're saying is, but he really didn't understand all that, even though he testified that he did.
What I'm saying, Your Honor, is repeating what the Tennessee Supreme Court said in the Crow decision, that
I'm
given...
I'm talking about this case, that's what your position is that even though he testified that he had been explained all this, he wasn't telling the truth or he really didn't understand it.
I would not characterize it that way, Your Honor. My position is that this court should be unwilling to assume because he signed a plea agreement that said the plea was voluntary and he was happy
It wasn't just that
with
he
his...
signed a plea agreement. He was under oath and told the court these things. He was under oath, obviously, and told the judge. Judge asked him a bunch of questions about his understanding of what was going on. And every time he had an opportunity to say, I don't, or, I'm confused about this, he never said that. He kept saying, I understand, I'm satisfied with my attorney. They've discussed this with me, they've gone over the facts with me. All that was testified to.
And that's what the U.S. Supreme Court has referred to as the imposing part of getting past the Rule 11 record. But it's not invariably insurmountable. And the same type of question and answering was gone through in the Crow case, as was gone through in this one, as was gone through in so many of the plea colloquies that we all see. But there were specific features of this that certainly should lead to a firm belief that Mr. Bennett did not voluntarily enter a guilty plea to 25 offenses.
But the post-conviction court found that he did.
The post-conviction court, yes, and also found that it was abundantly clear to the post-conviction court that he did not understand the concept of facilitation or principal liability for the conduct of others. Now, I'm not sure how that dovetailed into the ultimate ruling of the court, but the judge made that finding very, very clear, that that was apparent to him from reviewing the entire post-conviction record in this case and from the plea. Let me, if I may, switch briefly to the failure to file a motion to suppress the automobile stop in this case. The court simply said no evidence was presented to support such a motion. That's a legal conclusion, reviewed de novo. There were no credibility decisions whatsoever made that went into that particular ruling. The evidence we put in this record was introduced, and it showed how defense counsel could have followed up on the discovery and other leads to identify the officer that had called in the bolo with the license plate on this car, and then could have found out who was it that gave the license plate to that particular officer. The failure to investigate and follow up was not tactical. I'm going to switch then to, I believe, under our court's decisions in Phelps and Kimmelman, the two other issues. Would a motion have been meritorious, and would prejudice would have been involved? We brought Officer Kuykendall in to testify in this case that he was not assigned to work the shooting. He did not go in response to a 911 call to an apartment on Tacoma Drive to talk to Matthew Mount. We never knew where the prosecutor got that back in the day with that motion. He was just filling in for some other units. He heard about the call. He went, briefly discussed it with some of the officers at the scene, and then he started, just driving around seeing what he could find. A person he never knew, completely unidentified, came up to him and provided him the information regarding the license tag number. The officer didn't think to get his name, his address, anything else about him. The officer called in for the plate to find out, found out it came back, who it came back to, and a green Jeep, and he put that out as the bolo in this case. And that was what caused the stop in this case. The officer, Officer Hennard, who made the stop, he said, yes, it was in response to that bolo that had that specific information in it about the green Cherokee with that particular license plate number. We say this falls under the U.S. Supreme Court's ruling in J.L. regarding anonymous tipsters, anonymous informants in this case. I know this court, at one point, there was a case, State versus Drybell or Dribble, something to that effect, where very similar. K-9 officer was at the car wash. Man comes up to him in some sort of green vehicle and says to him, oh, by the way, over at the Walgreens, you're going to find so-and-so, and he's been selling drugs. That officer relayed that tip, which then led to an encounter with other officers over at the Walgreens, finding incriminating items that were then later suppressed in this case. We believe, created and shown by clear and convincing evidence that this would have been a meritorious motion to suppress. And with Officer Kuykendall's testimony and the contemporaneous radio traffic, it's all in this record, okay? That's the only conclusion that can be drawn, was this was an anonymous tipster whose credibility and other reliability were not followed up with to be able to give credence to that. Would the evidence, had the motion been granted, would it have, as I understand it, we then go back and look at maybe what the trial would have looked like, even though it's in the context of a plea. And would it have, how might that have affected a trial if Braylen Bennett had been successful with the motion to suppress? Well, first, he would have had to have gotten a severance from the other people in the car, because he would have had items that would have been suppressed they wouldn't have. Number one, his vehicle would have been suppressed. The license tag would have been suppressed. His statements he made in the back of the cruiser while he was being taken downtown would have been suppressed. The DNA that was taken from him would have been suppressed at that point. The any chance for the snitch gentleman who sat in the intake and said they were all out there talking about it and Mr. Bennett made inculpatory statements, that would have been suppressed. This would have definitely, the trial, that would have greatly affected, we say, Your Honors, the how that trial would have played out. And did I reserve time, Judge Wiedemeyer? I don't remember.
I don't think you did. I started to interrupt you early on, but if you need it, if you're through now, I'll give you a couple minutes on rebuttal if you need it.
Thank you. If you saw that I put in 18-point font, I would like to reserve 4 minutes. How in the world my mind goes by that? Thank you, Your Honor. I appreciate the consideration.
No problem. Thank you. General?
Morning again, Your Honors. Abigail Renard for the state. This court should affirm the denial of post-conviction relief. First, the petitioner voluntarily, knowingly, and intelligently entered his plea agreement. And second, each of the petitioner's ineffective assistance of counsel claims fail for the same reason. He cannot demonstrate that but for counsel's alleged errors, he would have insisted on going to trial. Thus, he cannot demonstrate prejudice. First, turning to the voluntariness of his plea. As the post-conviction court concluded here, the plea colloquy demonstrated that his plea was knowing, voluntary, and intelligent. So going through the factors, the petitioner was an intelligent 22-year-old college student. He testified that he had gone through, I believe, a year and a half of college. So he wasn't a freshman, he had completed high school, he was intelligent, and was a pretty good accounting major who was capable of handling and thinking about these complex topics. So the fact that this was a 25-count indictment that was just complicated, like admittedly it was a complicated indictment and a complicated case because there were so many offenses, that does not mean that he was incapable of understanding it. And the PC court here then found that his attorney was effective, that the petitioner had ample time to confer and prepare with his attorney, And the court explicitly credited the attorney's testimony that there was a meeting on Sunday. So during that meeting, lead counsel testified that he met with the petitioner, he went through the elements of the offenses, he talked through the elements, as you were saying, Judge Campbell, then he gave the petitioner the night to think about things, think through whether he wanted to enter the plea agreement, and then they came back Monday morning and again talked about the plea agreement. And then at that point, the petitioner, under oath, confirmed that he understood, confirmed that the facts of the case were as the prosecutor recited them, and entered his plea agreement. Then the petitioner, during the post-conviction hearing, acknowledged that his attorney had reviewed his rights with him. He acknowledged that during the plea proceeding as well. During the plea proceeding, he agreed that he understood the charges and punishments after both the prosecutor and the court reviewed the agreement in detail. So the prosecutor, during the plea colloquy, the prosecutor went through the agreement count by count and said, count one is, I don't remember the specifics of which count was which, but outlined exactly what the counts were and then said counts 2 and 3 merge into count 1 and went through each one. Then the court, after that, provided a more summary view of it and analyzed it as like the top counts, so just went through count 1 and didn't acknowledge that counts 2 and 3 were merging. But it still provided the same overall context for this plea agreement. The petitioner again testified that he was voluntarily entering the plea, that no one had coerced him, and when the court asked if he had questions, he said that he did not. Then
Remind me, was this whole proceeding involving like more than one, several defendants?
there were several defendants. I believe there were 3 or 4 other defendants involved in the plea proceeding. And then there was one final, Mr. King was the final co-defendant who did not receive an offer from the state. And so he ended up getting a continuance and went to trial later on, but the rest of the remaining co-defendants were all involved in this plea proceeding.
All right, thank you.
Yes. I think most significantly here, though, is that the petitioner acknowledged that after the plea proceeding, he followed up with his attorney to make sure that his agreement was still in place. So as was discussed earlier, the petitioner agreed as part of his plea agreement to potentially testify against Mr. King if the state called him. And when 2 of his co-defendants were called to testify in that trial, and Mr. Bennett was not, he followed it up with his trial counsel and said, hey, is this still, is my agreement still okay? Why haven't I been called? And that really demonstrates that this was a plea that he wanted. He had asked his attorneys to go for facilitation before. He wanted a plea agreement from early on in the case. Initially he was asking for a probationary sentence or a plea of that nature, but the state was simply not going to offer that. And initially the state wasn't going to give any offer to the petitioner, and lead counsel testified that, or perhaps it was co-counsel, one of the attorneys testified that the state had been unwilling to offer it because they viewed the petitioner as a leader in these offenses. So the fact that the petitioner was even able to get a plea agreement only came later in the case because the state was unwilling to offer it. So as the petitioner realized that he wasn't going to get his probationary plea agreement that he initially wanted, then he told his attorney to go for facilitation. So
Let me ask you this, because appellant made this statement that the court found that the defendant didn't understand what facilitation means.
So the context of that statement was kind of the court was talking about why the petitioner may have been unhappy with his plea agreement. And it was kind of in the context of, it's a difficult concept to understand that you can be held responsible for someone else's actions. And the court said something along the lines of, perhaps he doesn't fully understand or doesn't accept it, or that's a hard concept for a layperson to accept. And then the court went on to find explicitly that he was explained to, the concept was explained to him in a way that said that he could be held responsible for the actions of his co-defendants. So the court explicitly found that the concept was explained to him It's not clear whether or not the full extent of the petitioner's understanding about it. The state's position would be that he did understand it and just simply didn't like it, because it is a difficult concept that you can be held responsible for, a co-defendant's actions and something that you didn't necessarily do.
But the testimony of counsel was early on, he was trying to get a plea for facilitation.
Yes, there's an email from the petitioner to counsel telling him to go for facilitation.
I remember seeing that in the record. Okay, thank you.
You're welcome. So the PC court here reasonably concluded that the petitioner's plea was knowing, voluntarily, and intelligently entered. And ultimately, it's also a reasonable plea for the petitioner to have entered. He was facing first-degree felony murder charge, and the evidence here was very overwhelming. The petitioner, by his own admission, chose to enter the plea in part because all of his co-defendants had agreed to testify against him. One of the things that changed, and the attorney talked about the changing dynamics in this case as his co-defendants agreed to testify. There was DNA evidence putting him at the scene. He admitted from the beginning that he was at the scene. He was found in a Jeep near the scene with 3 of his co-defendants. There were descriptions that matched him. So the overwhelming evidence here was very, very problematic for the defendant, and it was reasonable for him to enter this plea. And then turning to the petitioner's claims about ineffective assistance of counsel. First, here he cannot demonstrate any prejudice in any of his claims because he has not alleged and cannot allege that but for counsel's errors, he would have or alleged errors, he would have insisted on going to trial. First, he never actually claimed that he would have gone to trial. He insisted that he would have wanted a new attorney and to start everything back over again. So the PC court observed that this was more an indication that he was unhappy with the length of his plea and more unhappy with kind of how things ended up, rather than that he was actually unhappy with entering a plea and would have gone to trial. Again, the petitioner had wanted a plea deal, and he began asking for one in early March. He sent follow-up emails checking on the status of a potential probationary plea. He asked about the plea again after Mr. King's trial, when he wasn't called to testify, and accepting the plea rather than going to trial was very reasonable. And then turning specifically to his claim about the motion to suppress, counsel here employed a reasonable trial strategy by filing a motion in limine rather than a motion to suppress. So first, the petitioner cannot establish that the failure to file a motion to suppress was objectively unreasonable. Here, the judge who had overseen the entire case from the motions hearings through the post-conviction proceedings had concluded that there was no proof that would have supported a finding that evidence should have been suppressed. The attorneys both testified that they didn't see any legal basis to file a motion to suppress, which is why they chose not to. And because of that, lead counsel made what he described as a strategic decision to file a motion in limine addressing the same concerns that the petitioner has raised here, and essentially making the exact same argument to the court that the petitioner has claimed he should have made. Through that motion, he addressed the same hearsay and confrontation issues related to the potential anonymous tipster, and made essentially the same argument that the petitioner is claiming he should have made in a motion to suppress. And at that hearing, he argued that the state had to prove that the confidential informant was reliable and all of those things, which the state would have had to prove. And here, a motion to suppress would not have been successful because that tip did not come from an anonymous source. At the hearing on counsel's motion in limine back before trial, the prosecutor explained that she planned to present the testimony from the witness who provided the license plate. And had lead counsel filed a motion to suppress, the prosecutor would have called that witness and established the reliability. And the fact that the officer did not recall the details of who that witness was, of exactly how he got the tag number years later at the post-conviction hearing, doesn't mean that a motion to suppress would have been successful at the time. And in the radio call, which was entered as an exhibit, the officer can be heard speaking to the witness and other officers. They're talking about the Jeep, they're talking about what's going on, and you can hear kind of their conversation going on. But the witness here was not some anonymous person that the state had no idea who he was. They were able and prepared to call him if necessary.
Was that the one whose son translated? Was that the witness?
No, it was not the witness who translated. This was a separate witness. I don't believe this witness made a 911 call. So he was, the officer ended up canvassing around the area and was just kind of knocking on doors and talking to different witnesses. So it was one of those individuals that he found in the neighborhood.
Did the Spanish-speaking witness through her son mention a Jeep as well?
One of the 911 calls mentioned a Jeep. I don't recall whether it was the Spanish-speaking witness. There were several 911 calls that night. I think a couple from the actual victims and then either 2 or 3 from other neighbors. And at least 1 or 2 of them had mentioned a Jeep as well, yes. And they all mentioned a Jeep Cherokee. I think some of them mentioned that it was green. Not all of them mentioned that it was green, I don't believe, but I would rely on the record for about specifically which one said which. And if this court has no further questions, we ask that you affirm the denial of post-conviction relief. Thank you.
Thank you, General. Can you punch in 2 minutes on the timer over there, Madam Clerk? Thank you.
Thank you, Your Honor.
Certainly.
Let me pick up on the very last matter involving the suppression issue in this case. What trial counsel ultimately settled on was where the tag number came from, the very first 911 call. He claimed that the man, Matthew Mount, on Tacoma Drive, gave a description of the Jeep, and his wife gave the tag number. That absolutely did not happen. The 911 call is in evidence. Transcript of that is in evidence. The first call was the only call, 911, that ever mentioned even a vehicle. And it was just a Jeep, and the color was not mentioned on that. Respectfully, an in limine motion does not serve the same purpose as a suppression motion. It just simply doesn't. Officer Kuykendall, he remembered what happened. We had the radio traffic. He had reviewed it. The prosecutor had given him that to review, had talked to him about it. The fact that he didn't know the name of the man or anything about him, that's kind of the whole point of it being an anonymous tip, Your Honor. The one thing that's you don't usually see in these cases, where you'll have a petitioner who'll try to say, oh yeah, if I'd known this or this, I would have insisted on going to trial. And we're all, I think, reasonably skeptical of those kind of claims. What we have in this case is the contemporaneous emails from Mr. Bennett expressing his clear intent. He asked back in, this was in March of 15, before any ruling even on the severance motion. I want a plea deal. I will only take probation. If she doesn't want to give probation, we can go to trial. That kind of begs the question, where in the world did he get the idea any of these charges he could have gotten probation on, unless the incorrect analysis at the very beginning that was done?
Well, now, I know that there's a lot of stuff that happens in the jail. And people talk about, this is what you should get. I mean, you get all this jailhouse lawyers come and tell you, this is what should happen, this is what should happen. And they have all kinds of crazy statements as, I'm going to get probation for this, or I'm going to get diversion for this. And it doesn't come from the attorneys, it comes from somebody in the jail.
Well, there apparently was never a response by his attorneys to cut it out with the probation. This is just not going to happen in this case. But he also says, now we're going to, this would be Thursday before the trial was scheduled to begin on Monday, okay? There was a motion hearing that day on the motion in limine. And he said, Mr. Bennett said that was the very first time he ever heard the word facilitation. His attorney was talking to him about an offer to the other defendants that was described as 15 at 30 stacked hard to the 25. And Mr. Bennett remembered that, and he was writing and asking, well, tell Greg to try for facilitation, 15 at 30. That's what he understood. I know he wants me not there, period. However, I didn't have anything to do with the house, so therefore, instead of 40 plus, I can get less. We may not beat it all, but most of it. Then at Saturday morning at 8:52, before the trial was scheduled to begin on Monday, Mr. Bennett sends an email. Okay, I'm going all the way with this. Let's do it. That was his mindset. That was his frame of mind as of Saturday, that yes, he was intent on going to trial.
And apparently something changed between Saturday and Monday. And what the lawyers are saying is, he saw that these other people were taking pleas and could wind up testifying against him. So things changed pretty dramatically the morning of trial.
Two things he said, Your Honor, was that in a very eloquent way, Mr. Bennett explained how when counsel came in Monday to him, you know, he never heard anything after he say, okay, I'm ready to do it, let's go. Monday. He said he didn't see the passion in his attorney's eyes. The attorney just kept talking about negative aspects of this case. It literally just wore him down. Now, there was suggestion that, well, what caused him to plea was he found out Monday that the co-defendant, Dwayne Love, his co-defendant was going to be against him, and that finally stacked it up and convinced him that he was going to have to plead guilty. In this record, Exhibit 38 is a CD admitted without objection from the state of the post-plea interview of Dwayne Love. Mr. Bennett said, I wasn't afraid of him pleading in this case. I wasn't afraid of what he'd say about me. No, that didn't influence me. And you look through Mr. Love's statement, and there is a transcript ID to that, you'll see what Mr. Love had to say, such as Mr. Bennett was the one, when they got there, that said, hey guys, maybe let's rethink this. He was the one saying that. Plus, Mr. Love also confirmed Mr. Bennett never went in that house. Mr. Bennett was not afraid when Mr. Love said he was going to take the plea agreement. Thank you.
All right, thank you, but you got something
Ma'am.
else?
Perhaps because I'm somewhat of a dinosaur, Your Honor, or perhaps because I was with Judge Witt too long, but I'm going to suggest that this really is one of these records that it is really better understood if it is digested in paper form rather than trying to go through. I know we all try to do that now, but I offer that humble suggestion that it probably will make more sense if it's reviewed that way. Thank you very, very much, Your Honors. I
Our
appreciate it.
office still likes the paper way also, so. And as always, Ms. Short, you've done an excellent job advocating for your client and have written an excellent brief, and we appreciate that.
Thank you, Your Honor.
And your brief was excellent also, General. We'll study it very carefully, the record and the briefs, and take the case under advisement and render an opinion. One more case this morning. Madam Clerk, call